Hey guys, tonight I need to tell you about 100 minutes. Not 100 days, not 100 hours, 100 minutes. That is how long 12 men in Queens, New York, stayed in a room in the second week of May, 1927, before they came back out and sent 2 people to the electric chair. 1 hour and 40 minutes. You could roast a chicken in that. You could ride a train from Long Island City into Manhattan, walk 2 blocks and ride it back, and still have time to spare. I want to be straight with you before we go one step further, because this is not one of those cases where I spend 2 hours asking whether the woman did it. She did it. Ruth Snyder helped kill her husband Albert in their own house in Queens Village on the night of the 20th of March, 1927, while their 9-year-old daughter slept down the hall. She confessed. She had taken out life insurance on him. She had been paying the premiums herself, quietly, out of the household money. Afterwards, she arranged the rooms to look like a burglary, and she hid the jewelry she claimed had been stolen underneath her own mattress, where a detective found it before lunch. There is no reading of this record in which she is innocent. I am not going to insult you by pretending there might be one. So that is not our question tonight. Here is our question. Before the trial began, Ruth Snyder's lawyers filed a motion, an ordinary motion, the kind that gets filed and denied 100 times a week in courthouses all over the country. They asked that she be tried by herself. 2 parties stood up to oppose that motion. The first was the state of New York. You would expect that. The second was Henry Judd Gray, the man she was accused of doing it with, the man whose own confession laid the planning at her feet. He sent his lawyers into court to stand shoulder to shoulder with the prosecutor and argue that the 2 of them should be tried in the same room, in front of the same 12 men, at the same time. The judge agreed with them. The motion was denied. Then the case ran its whole course. Both of them were convicted. Both of them were sentenced to die. And the papers went up to the highest court in the state of New York, which looked at everything in the file. The killing, the confessions, the staged burglary, the insurance, all of it. And it wrote down, in its own words, that the evidence was clearly sufficient, and that there was no ruling at the trial the defendants could reasonably complain about, and that only one question remained, worth considering at all. One question, out of the entire case: whether denying Ruth Snyder a trial of her own had cost her a fair one. Hold on to that. We are coming back for it, and when we do, it is going to land harder than it just did. Before we go into the house, I need you to take 3 things with you, not as theories, as objects. The first is a word, indemnity. It is an insurance word, and it means to be made whole again, to be restored, to be put back the way you were before the loss. Keep that word somewhere you can reach it, because it is going to come apart in your hands later. The second is that motion, the request to be tried alone, and the 2 parties who killed it. The third is a date that has nothing to do with a murder, 1926. The year before any of this happened, the legislature of New York quietly amended a section of the criminal code, and that amendment is the hinge the whole thing turns on. Nobody in Queens Village noticed. Nobody was supposed to. 1 word, 1 motion, 1 amendment. That is what you are carrying. If this is the kind of history you came here for, the version where the file is stranger and colder than the story everybody repeats, then subscribe. So the next time we open a case like this one, you are already in the room. Now, we cannot start on the 20th of March, 1927. If we start there, we get a monster and a sash weight and nothing to think about. To understand what happened in that house, we have to start with something much quieter and much older and much sadder. We have to start with a photograph of a dead woman hanging on a wall. Her name was Jessie Guichard. She had been engaged to Albert Snyder, and she had died about 10 years before any of the events in this story. Albert never really put her down. He kept her picture. He hung it in the home he shared with his wife. He told people that Jessie Guichard had been the finest woman he ever knew, and he went on saying it after he was married to somebody else. He had a small boat, and he named the boat after her. I want you to hold that in your hand for a moment. Not as a motive, not yet. Just as a fact about a room. There was a woman living in a house where another woman's face was on the wall, and the boat outside had that other woman's name painted on the back of it. Albert Snyder was an art editor. He worked at a magazine about motorboats, laying out pages, choosing pictures, making the thing look right. By every account, he was competent, particular, and not warm. He liked order. He liked his own quiet. He was more than 10 years older than the woman he married. She was Ruth Brown before she was Ruth Snyder. Her father had come from Norway, her mother from Sweden, and the family was working class in the plain, unremarkable way that most of New York was working class in the first years of the century. She did not finish high school. She went to business school instead and learned to type and take dictation. Then she went out and got office work. For a young woman in that city at that time, that was a real achievement and a real ceiling at once. She met Albert Snyder through the magazine. They married. And within a few years, they were doing what a great many couples in that decade were doing, which was moving out of the crowded part of the city into the part that was still half fields. Queens Village, a corner house, a porch, a patch of grass, their daughter Lorraine. If you had driven past it in the winter of 1927, you would have seen exactly nothing. That is the first thing about this case that matters. Everything that went wrong in that marriage went wrong entirely inside it, with the curtains open, in a neighborhood full of people who noticed nothing because there was nothing on the outside to notice. The marriage was bad. I want to be careful here, because this is the exact place where storytellers start inventing, and I am not going to do that with you. What the record supports is this. She said he was cold to her, that he called her by the dead woman's name, that he was harsh with her, that he preferred the memory of Jessie Guichard to the fact of Ruth. He is not here to answer any of it. He never gave a statement about his marriage, because by the time anybody was asking, he was dead. Every single word we have about the inside of that house comes from the woman who killed him, given while she was trying to save her own life, or from her lover, given while he was trying to save his. That is not nothing. It is also not testimony you would want to hang a conclusion on. So I am going to tell you what she said, and I am going to keep reminding you who was saying it and why. What we can establish without her is the paperwork. And the paperwork is where this case actually lives. Now I have to explain something about the law of New York in 1927, because without it, you will misread everything that follows, and most retellings of this case simply leave it out. I am not going to offer you an excuse for a murder. There is no excuse. I want you to understand the actual shape of the room she was standing in. In the state of New York, at that time, there was essentially one ground for divorce: adultery, not cruelty, not desertion, not the fact that your husband keeps another woman's photograph on the wall and calls you by her name. One ground. You had to prove that your spouse had committed adultery, in court, with evidence. That was the law in New York for most of its history, and it was famously the strictest arrangement of any large state in the country. Neighboring states were easier. That is why an entire industry existed in the 1920s of people traveling out of state to end marriages, and why a smaller, shabbier industry existed alongside it. Manufactured evidence, hired women, staged hotel photographs, the whole grubby machinery of getting a New York judge to see what he required to see. So run Ruth Snyder's options. She could stay. Cold house, dead woman's picture. A husband more than 10 years older who preferred a memory. She could leave and be a woman in 1927 with a daughter, no husband, no divorce, no property, and a business school certificate. Separation without divorce meant no remarriage and, in practice, very little money. She could prove her husband's adultery. But her husband was not committing adultery. He was faithful to a dead fiancé and cold to a living wife, and there is no cause of action for that in the New York statute books. Or she could commit adultery herself, which is the one thing she actually did, and which under that same law would have given him the grounds and left her with nothing. I want to be exact about what I am claiming, because this is the sentence people twist. I am not saying the law made her do it. Thousands upon thousands of women in New York were in unhappy marriages under that identical statute and did not kill anybody, almost all of them. That is the overwhelming majority, and it matters enormously. What I am saying is narrower, and I think harder. The legal system offered her no door, and when she chose the worst possible substitute for a door, the same legal system tried her in a room that could not acquit her. Then it killed her. Then a newspaper explained that this was a triumph for women's equality. The state would not let her out of the marriage. Then it would not let her out of the trial. That is not a defense of Ruth Snyder. That is a description of an institution that was closed at both ends. In 1925, Ruth Snyder began an affair with a man named Henry Judd Gray. Gray sold corsets. That detail has been used for a century as a punchline, and I am going to ask you to set the joke down, because the job matters. A corset salesman in 1925 was a traveling man. He had a territory. He had hotels. He had a reason to be in a different city on a given night, and a company that could confirm he had been there. He had, built into his ordinary working life, the raw material of an alibi. He was married. He had a daughter. He was, by every description that survives from people who dealt with him, mild, careful, a little soft. He wore glasses. He drank more than he should have. He was the kind of man nobody describes as dangerous, and the papers would eventually make an enormous amount of that. They met in the city. They used hotels in Manhattan. They wrote to each other. For about 2 years, this was simply an affair, one of thousands, and if it had stayed an affair, we would never have heard of either of them. Then the insurance happened. Here is where I am going to slow down, because this is the part that the movies took and the part everybody gets slightly wrong. Ruth Snyder wanted her husband insured. She got him insured. But she did not do it in one clean stroke, and she did not do it alone. What she did was work an insurance agent. There were policies. The one that ended up mattering was worth $48,000. And the reason it mattered was not the number. It was a clause. The policy carried what the industry calls a double indemnity provision. In plain speech, it meant this: if Albert Snyder died the way most men die, of illness, of his heart, in a bed, the policy paid its face value. But if he died by violence, by accident, by something sudden and external and unexpected, it paid twice. Twice. Say that to yourself in the voice of somebody sitting at a kitchen table doing arithmetic, not in the voice of a villain, in the voice of a bookkeeper. If he gets sick, this is worth one amount. If something happens to him, it is worth two. $48,000 in 1927 was not fortune money, but it was life-changing money for a woman who had gone to business school because high school was not going to be paid for. It was a house outright and years of not worrying. Doubled, it was something else again. And I want to say something about the clause itself, because we tend to treat it as her idea, and it was not. It was a product. A double indemnity provision was sold. It was marketed. Insurance companies in the 1920s competed on features, the way everything is sold in every decade, and paying twice for a violent death was an attractive feature. It cost the customer very little extra, because violent deaths are statistically rare, and it felt like enormous value. You were buying reassurance against the specific fear that keeps people awake, not the slow illness, the car, the machine at the works, the stranger on the stairs. The industry understood the other side of it perfectly well. Any actuary can see it in about 4 seconds. A contract that pays double if a person dies violently creates a financial reason for somebody to die violently. That is not a subtle observation. It has a name in the trade. It is called moral hazard, and insurers have been writing about it and pricing for it since long before 1927. So the companies knew. They knew that among the many thousands of ordinary families buying that rider for ordinary reasons, some very small number of people would look at it and see an instruction. They wrote it anyway, because the arithmetic across the whole book of business worked, and because the customers wanted it. That is a completely rational commercial decision, and I am not calling it a crime. I am pointing out that when we tell this story, we say a woman looked at an insurance policy and saw a way to kill her husband, as though the seeing were the whole event. But somebody had to write the clause. Somebody had to price it. Somebody had to train an agent to sell it and pay him a commission for selling it. And somebody had to accept a signature on it without checking whether the man whose life was being priced had ever heard of the document. Ruth Snyder did not invent double indemnity. She was its customer. She was, in fact, exactly the customer it was designed to attract, and the industry had known that customer existed for a very long time. And Albert Snyder did not know the policy existed. That is the second thing in this case that I need you to actually absorb rather than nod at. A life insurance policy is a contract on a man's life, and the man whose life it was had not agreed to it. It carried his signature. The signature was not his. The agent who wrote it was involved in that. He was, in the end, dismissed by his company and imprisoned for forgery. I am not editorializing. That is what happened to the man who handled the paper. So sit with the shape of it. There was a document in the world that turned Albert Snyder's violent death into a specific sum of money, payable to his wife. Albert Snyder had never been told it was there, and the version of his name on it had been written by somebody else's hand. Nothing had happened yet. Nobody had been hurt, but the mechanism existed, and it was quietly waiting, and the premiums were being paid out of the money he handed his wife for the house. Now I have to tell you about the attempts, and I have to be careful again. Judd Gray said, later, under oath and in his confession, that Ruth Snyder had tried to kill her husband before that March night. He described a series of efforts: gas, poison, various small domestic arrangements that did not work. He put the number at around 7 attempts. Every one of them survived. I want to flag the source problem, because it is enormous. That count comes from Gray, and it comes from Gray at the exact moment when his entire strategy for staying alive was to convince everyone that Ruth Snyder was a force of nature who had swept him along. A man in that position has every reason to describe a long campaign he was dragged into, and no reason at all to describe a single evening he agreed to. Albert Snyder never reported being poisoned. There is no medical record of it. Some of what Gray described, Ruth Snyder denied. So here is where I land, and I want you to land there with me. There is real support in the file for the idea that Albert Snyder's death was not a sudden thing, that it had been circling the house for a while. There is no reliable way to say it happened 7 times. When you hear that number repeated as fact, you are hearing a man on trial for his life, counting. What is certain, because the paper is certain, is that by the winter of 1927, the arrangement was fully assembled. The lover existed. The policy existed. The clause existed. The premiums were current. And the man, asleep in the front bedroom, was, on paper, worth considerably more dead than alive, in a document he had never read, with his name on it in handwriting that was not his. That is not a motive. A motive is a thing inside somebody's head, and I cannot get in there, and neither can you. That is an instrument. Now, before we go into the 20th of March, I need to explain one more thing, because it is going to matter enormously later, and if I explain it later, it will feel like an excuse. I need to explain what a joint trial is, and why it exists, and why intelligent people built it on purpose. When 2 people are accused of committing one crime together, the state has a choice. It can try them one at a time, or it can try them side by side. Trying them side by side is the older and, for most of legal history, the more natural option, and there are honest reasons for it. It is faster. Witnesses testify once instead of twice. Juries are pulled from the community once instead of twice. Courts are not infinite, and neither is public money. But there is a better reason than money, and it is worth respecting. When 2 defendants are tried separately, each trial happens in a room where the other man is only a name. He is a story the lawyers tell. He cannot be questioned because he is not there. So each jury hears one version of a 2-person night, and neither jury ever sees the 2 accounts stand up next to each other. Try them together, and the jury gets the whole event in one room. That is not a trick. That is an argument for the truth. I mean that. Hold the strongest version of the rule in your mind, because I am about to show you what it did to a specific woman, and the demonstration is worthless if I have set up a straw man first. Joint trials exist for good reasons. In this case, the good reasons produced a room that no honest system should have built. And in 1926, the year before Albert Snyder died, the legislature of the state of New York changed the law that governed exactly this decision. Section 391 of the Code of Criminal Procedure, amended by the laws of 1926. After the amendment, the rule read, in substance, that defendants indicted together may be tried separately or together, and that the choice belongs to the discretion of the court. The discretion of the court. One judge. No standard written into the sentence. No test. No list of factors. A door with no rules on it, and one man's hand on the handle. Nobody amended that statute with Ruth Snyder in mind. She was in Queens Village, paying premiums when it passed. The legislature was tidying up procedure, the way legislatures do, in a session nobody remembers. But when her lawyers walked into court and asked for a trial of her own, that sentence was the whole of the law they were arguing under. And the highest court in the state would later look at that sentence and say out loud that it could not believe the legislature had meant to hand a judge an arbitrary choice. Could not believe. That is a court's way of admitting the words on the page do not say what the words on the page ought to say. We will get there. For now, understand the state of the world on the 19th of March, 1927. A house on a corner in Queens Village. A man asleep who edited pictures of boats for a living and kept a dead woman's photograph on his wall. A 9-year-old girl in another room. A wife who had learned to type and had learned, more recently, what a double indemnity clause was worth. A traveling salesman with a territory and a hotel room and a reason to be in Syracuse. A policy in a drawer with a forged signature on it, and a fresh amendment to Section 391 sitting in the statute books, unread, unnoticed, waiting. Every single piece was already in place. Nobody had to invent anything. All that was left was the night. Before we walk into it, I want to put one more thing on the table, and it is the reason I chose this case for you at all. There are 2 ways this story is usually told. The first is the tabloid way, and it was invented in 1927, and it has never really stopped. In that version, Ruth Snyder is a type, a blonde, a vampire, an ice woman from the suburbs who bewitched a weak little corset salesman and had her husband killed for money. She is not a person in that version. She is a warning about wives. The second is the film way. This case fed directly into the hardest American crime fiction of the following decade. If you have ever watched a story about an insurance policy, a bored wife, a doomed man, and a clause that pays double, you have watched the shadow this case through. The names changed. The clause did not even change its name. Both of those versions are about her character. I am not interested in her character tonight. Her character is not in dispute, and it is not the point. She helped kill a sleeping man for money, and she lied about it to police within hours. I am interested in the room they tried her in. I am interested in a motion that took 10 minutes to deny. And I am interested in what the highest court in New York did with all of it. 2 confessions, a forged policy, hidden jewelry, a staged burglary. That court said the only question left worth asking was about that motion. Because here is the thing that I have not been able to put down since I started reading this file. Ruth Snyder was guilty, and the trial that convicted her could not have acquitted her. Those 2 sentences can both be true at once. Most people cannot hold them at the same time, and the entire history of how this case is remembered is the history of people refusing to. The papers of 1927 refused, in one direction. They decided she was a monster, and so the machinery that killed her was justice, and there was nothing to examine. And there is a modern refusal in the other direction, where people decide that if a trial was unfair, the defendant must have been wronged in some larger way, must have been more innocent than she was. Neither of those is what the record says. The record says a woman planned her husband's death and got a trial designed to make her conviction inevitable, and that both of those facts are written down in the same file, in the same handwriting, by the same institutions. She was going to be convicted no matter what room they put her in. I believe that. I think you will too, by the end. The evidence against her was overwhelming, and it was independent of anything Judd Gray ever said. The jewelry was under her mattress. The house had not been broken into. The policy was in the drawer, which is exactly why what they did is so hard to look away from. They did not need the room they built. They built it anyway. So let us go to the house. The date is Sunday, the 20th of March, 1927. Albert and Ruth Snyder had been out that evening at a card party a few doors down. It was the sort of thing people did on a Saturday night in a new neighborhood, where everybody was still learning each other's names. They took Lorraine with them. They came home late. Albert Snyder went upstairs to bed. Judd Gray was already inside the house. He had come down from Syracuse. He had established, carefully, that he was in Syracuse. He had arranged for a fellow salesman to muss up his hotel room, hang out a "Do Not Disturb" sign, and mail a letter for him so that it carried the right postmark. He had bought a ticket, ridden the train south, and come to a house in Queens Village on a Saturday evening carrying, among other things, a window sash weight. I need to say clearly what a sash weight is, because it has become a lurid word and it should not be. In an old wooden window, the kind that slides up and down, the weight of the frame is balanced by an iron cylinder hanging on a cord inside the wall. That is a sash weight. It is a piece of household hardware. It is about 5 pounds of iron shaped like a length of pipe. There was nothing exotic about it. There was one in every window in America. He also had chloroform. He also had picture wire, the kind you would use to hang a framed photograph on a wall. Hold that. Picture wire. There was a photograph of Jessie Guichard hanging in that house, and there is no evidence, none, that the wire came off it or had anything to do with it. I am not going to build you a symbol out of a coincidence. I am telling you what was in his hands because the record tells us what was in his hands, and because the ordinariness of the inventory is the most disturbing thing about it. A window weight, a bottle from a chemist, a length of wire for hanging pictures. Nothing in that list had to be bought from a criminal. Everything in that list was already in the walls and the drawers and the cupboards of every house on that street. That is what this case is. Underneath the blonde and the vampire and the ice matron, 2 ordinary adults with ordinary household objects and 1 piece of paper with a clause in it. The rest of that night I am going to give you plainly, in order, without decoration, because it does not need any, and because the people involved deserve the dignity of a plain account. They went into the bedroom where Albert Snyder was sleeping. He was struck on the head with the sash weight. He did not die from it. He fought. Both of them later described a struggle, and the 2 descriptions disagree about almost everything except that there was one, and that it did not go the way either of them had expected. A man who has been hit in the head while sleeping and who is still moving is not a plan anymore. He is an emergency. Chloroform was used. Rags were pushed into his nose and mouth. The picture wire was tied around his neck. He died of some combination of those things. The medical evidence at trial addressed the question. The 2 defendants spent the trial pointing at each other over the top of it. I am going to leave the apportionment where the record leaves it, which is unresolved and contested. What is not contested is that Albert Snyder was killed in his own bed by 2 people who had come into the room to do it. It took longer and was worse than either of them had imagined when they planned it in a hotel. Then they started arranging the house. This is the part that decided everything. They pulled out bureau drawers and emptied them on the floor. They scattered the contents. They made the rooms look ransacked. the way rooms look in a story about a burglary. They took Ruth Snyder's jewelry and they hid it inside the house. Then Judd Gray tied his lover's hands and feet loosely and left her lying in the hallway and left the house and went back to Syracuse. The story they had agreed on was that intruders had broken in, knocked Ruth Snyder unconscious, tied her, killed her husband, and taken her jewelry. 2 men, she would say. She described them, and she gave them a nationality. She told the police that the men who did it were Italian, 2 large Italian men. I want to stop on that for 1 second, because it is small in the file, and it is not small at all. In 1927, in New York, that was not a neutral detail. It was the most efficient lie available. It was chosen because she believed, correctly, that it would be believed. That is a fact about her, and it is a much larger fact about the city she was lying to. Nobody was ever arrested for it, but she reached for it first, before she reached for anything else, and she reached for it in the hallway of a house with her husband dead upstairs and her daughter waking up. At around 8 in the morning on the 20th of March, 9-year-old Lorraine Snyder found her mother lying in the hallway with her hands and feet tied. Her mother told her to go and get the neighbors. That is where the police came in. And the police looked at the scene for about as long as it takes to walk through a house, and they did not believe a word of it. The first thing that went wrong for Ruth Snyder was that she did not look right. That sounds like an unkind observation, and it is actually a forensic one. She had told the police that 2 men had knocked her unconscious and left her tied on the floor of the upstairs hall for something in the region of 6 hours. A person who has been struck hard enough to lose consciousness and then left bound on a wooden floor overnight is in a particular condition when help arrives. There are marks. There is stiffness. There is cold. The detectives looked at her and saw a woman who had been lying down. Her hands and feet had been tied, but they had been tied the way you tie somebody who is going to need to get loose. Loose enough that the circulation was fine. There was no serious injury to her head. The story required violence, and the violence was not on her. Then they walked the house. A burglary leaves a signature, and the signature is boring and consistent and very hard to fake, because burglars are in a hurry and burglary is work. Somebody has to get in. That leaves a mark on a window or a door or a lock. Somebody has to move through unfamiliar rooms in the dark, looking for things worth carrying, and that leaves a particular kind of mess, the mess of searching. The mess in that house was the mess of arranging. Drawers had been pulled out and their contents put on the floor. That is what it looked like, but the drawers at the bottom were open too, and anyone who has ever actually rifled a chest of drawers knows you start at the top, and you do not bother closing anything behind you. Cushions were disturbed in rooms where nothing was kept. Nothing in the pattern matched a person hunting for valuables in a house they did not know. It matched a person who knew exactly where everything was and was distributing it. And the point of entry was the problem that never went away. There was no convincing sign that anybody had broken into that house. Not a forced window, not a sprung lock, nothing. 2 large men had supposedly come in, overpowered a woman, killed a man in a struggle upstairs, ransacked several rooms, and left, without leaving a mark on the building. Then a detective went upstairs and looked under the mattress in Ruth Snyder's own bedroom and found the jewelry she had reported stolen. I want you to hold the sequence of that morning, because the shape of it matters. This was not a case cracked by science. There was no laboratory. There was no fingerprint that undid her. Every single thing that destroyed her story on the 20th of March, 1927, was available to anybody standing in that hallway with their eyes open. The knots were wrong. The body was not injured. The house was not entered. The stolen property was in the house. That is not an argument. That is an inventory. And an inventory, unlike a story, does not have to be believed. It only has to be read. The interrogation began that day, and it went on for hours. I have to slow down here again. What happened in that room is going to matter later, in a way that nobody inside it understood at the time. Ruth Snyder was questioned by detectives without a lawyer. That was ordinary in 1927. There was no requirement that anybody tell her she could stay silent. There was no requirement that anybody tell her she could have counsel. The rules that would eventually govern a room like that were 40 years in the future. So a woman whose husband had been killed the night before, who had been on the floor of her own hallway, sat in a room with police officers and answered questions for a long time, alone. Her story shifted. Details moved. The number of men changed shape. The timings did not fit the medical picture. And at some point in that long day, the detectives put a name in front of her. The exact mechanics of how the police got to Henry Judd Gray are reported inconsistently, and I am not going to pretend to certainty I do not have. The versions in the newspapers of the time and in the books since do not agree. Some say a small address book. Some say a canceled check or correspondence or a piece of jewelry with initials on it. What is consistent across the accounts is that within hours of arriving at that house, the police had a man's name, and that the name did not come from a witness. It came from her own belongings, and when they said the name, she gave him up. She confessed, and her confession did something very specific, which is the thing that decides this entire case, so I want to name it plainly, rather than let it slide past. She did not confess to killing her husband. She confessed to a murder committed by Judd Gray. In her account, the plan was his. The violence was his. She had tried to stop him. She had at one point believed she had talked him out of it. She was not in the room when the blows landed. She was a woman who had been having an affair with a man who then, on his own initiative, came into her house and killed her husband. That is what a confession looks like when it is written by somebody who has already worked out that there is going to be a trial. Meanwhile, in Syracuse, Henry Judd Gray was doing exactly what he had planned to do, which was to be somewhere else. He had built the alibi with real care, and I want to walk you through it, because the care is the thing that hanged him. He had a hotel room in Syracuse. Before he left it, he arranged for the bed to be disturbed so it would look slept in. He hung a "Do Not Disturb" sign on the door so the staff would not go in and find nobody there. He gave a letter to a fellow salesman with instructions to post it from Syracuse so that the postmark would put him in that city on the right day. Then he took a train to New York, did what he did, and took a train back. When the police came for him, he laughed at them. The word that comes down to us is that he said it was ridiculous. And in a sense, he had earned the confidence, because he had a hotel room that looked occupied and a letter with the right postmark and colleagues who would say he had been in town. Then the officers told him that Ruth Snyder had confessed, and he folded completely. He admitted being in the house. He admitted the sash weight. And then he did precisely what she had done, in the opposite direction. He said he had not wanted to kill Albert Snyder. He said the plan was hers. He said she had worked on him for months, that she had made the arrangements, that she had participated in the killing itself. He said she had threatened to tell his wife about the affair if he refused. He also said, and this became the spine of his defense and the spine of how the public understood him, that she had a kind of power over him. He described being looked at until he was not himself. Before the trial even began, he was giving the newspapers language about her eyes and about being hypnotized, and the papers printed every word. So now, stop and look at what exists. 2 confessions. 2 people who both admit being in a house where a man was killed, neither of whom says they did it, each of whom says the other one did. Now, here is the piece of law that this whole story turns on, and I need you to actually have it, so I am going to explain it as carefully as I can. A confession is evidence against the person who made it. That is all. It is not evidence against anybody else. There is a serious reason for that, and it is not a technicality. When a man tells the police that somebody else planned a murder, he is a witness with the strongest possible motive to lie. He is not describing the world. He is negotiating for his life. If his statement could be used as proof against the person he is accusing, then every accused man in the country would have a reason to name a co-defendant, and the naming would do the work of evidence. So the law says no. Your confession convicts you. It does not convict the person you point at. Which means that on paper, in the last week of March 1927, the state of New York had a problem. It had a very strong case against Judd Gray, built on Judd Gray's own confession. And it had a very strong case against Ruth Snyder, built on Ruth Snyder's own confession, plus the knots, plus the mattress, plus the unbroken windows, plus the policy. But the single most devastating thing anybody had said about Ruth Snyder, the account in which she was the architect of the whole thing, had come out of Judd Gray's mouth, and Judd Gray's confession was not evidence against her. If she were tried alone, the prosecutor could not read it to her jury. He could not hand it to them. He could not quote it in his summation. Unless the 2 of them were in the same room, because in a joint trial, both confessions come in. Each one comes in against the man or the woman who made it, which is lawful and correct. But they come in out loud, in front of one jury, which hears both. And the judge instructs that jury to keep them apart, to use each confession only against its author, to hear Judd Gray describe Ruth Snyder planning a murder, and then to wall that off and not let it touch the question of whether Ruth Snyder planned a murder. I want you to try to actually do that, right now, in your own head, with something small. It cannot be done, not by 12 men in Queens, not by 12 judges, not by anybody. You cannot hear a thing and then not have heard it. The instruction is a legal fiction. Lawyers have known it was a fiction for as long as there have been joint trials. Courts have gone on giving it anyway, because the alternative is to admit that the room itself is the problem. So the state of New York had a choice in front of it. In the spring of 1927, 2 rooms or 1. 2 rooms meant 2 trials, each built only on what the law allowed against that defendant. 1 room meant every word both of them had ever said, in front of 1 jury, at the same time, with an instruction nobody could follow. The district attorney of Queens County was Richard Newcomb. He indicted them together. I am not going to tell you that was a corrupt decision, because I have no evidence that it was, and because I think something more uncomfortable than corruption was going on. It was an obvious decision. It was the decision almost any prosecutor in America would have made, then or now. It was efficient, it was lawful, it was available, and it was going to work. That is the whole problem. Nobody in this story had to do anything unusual. Now, while all of that was being arranged inside the courthouse, Something else was happening outside it, and it was arguably worse. By the Tuesday after the killing, the newspapers of New York had printed the full text of both confessions. Read that again, slowly. Both confessions, in full, in the papers, before an indictment, before an arraignment, before a lawyer had stood up in a courtroom and said a word on either of their behalf. Every literate adult in the New York metropolitan area could sit down with a cup of coffee and read Ruth Snyder's account of the night. Then turn the page and read Judd Gray's account of the same night. Then compare them and decide which of the two was lying. Which is exactly what a jury is for. The public did the jury's job first, and it did it in March. By the time 12 men were actually sworn in at the end of April, every one of them had spent 5 weeks in a city that had already reached a verdict. The medical evidence deserves a moment, and I am going to give it to you the way a coroner would, without adjectives. Albert Snyder was found in his bed. There was injury to his head, consistent with blows from a heavy blunt object. There was picture wire around his neck, and it had been tightened. There were chloroform-soaked rags pushed into his nose and mouth, and chloroform was present in his airway. 3 separate methods of killing, applied to one man, in one bed, in one night. I want to explain why that matters legally rather than dwell on it, because the number of methods is the thing the 2 defendants spent the whole trial fighting about. If a man dies of one thing, you can sometimes work out whose hand did it. If a man dies of 3 overlapping things, applied in sequence, by 2 people who each say the other did the important part, the medical evidence cannot resolve the question of authorship. It can only establish that both of them were doing something, which is precisely the condition in which a jury stops weighing forensics and starts weighing character. And by the end of April, after 5 weeks of newspapers, the character of both defendants had already been established for the public. Established by people who had never met either of them, printed in type large enough to read from across a subway car. I want to give you some sense of the temperature, because I do not think a modern description of media frenzy quite conveys it. The 1920s, in New York, was the moment the tabloid was invented as a form. The New York Daily News was the best-selling paper in America. It was built on photographs and short sentences and enormous headlines, and it was in a circulation war with rivals who were built the same way. A story like this was not covered, it was farmed. They gave her names. She was called a synthetic blonde. She was called a vampire wife. One paper produced the phrase Ruthless Ruth, the Viking ice matron of Queen's Village, which tells you almost nothing about the woman and almost everything about what was being sold. Notice what all of those names have in common. Not one of them is about the killing. They are all about her. Her hair, her blood, her coldness, her Scandinavian parents. The papers were not describing a crime. They were describing a category of woman and warning their readers about her. And notice what they were not calling Judd Gray. He had swung a sash weight at a sleeping man's head. In the coverage, he was the weak one, the drunk one, the little salesman, the man who had been hypnotized. He was given a story in which things happened to him. One paper, during the trial, hired a phrenologist. That is a person who claimed to read character from the shape of the skull. It was already understood to be nonsense by educated people in 1927. A newspaper paid one to examine the defendants and tell the public what kind of people their heads proved they were. I want to be fair here, because there is a version of this where I make the press the villain and let everybody else off, and that is not honest either. The papers did not invent the public appetite. They measured it, very precisely, in copies sold. When the Daily News eventually put the most notorious photograph in American newspaper history on its front page, the thing that tells you the most about that day is not what the editors chose. It is that the edition sold out. That comes later. Hold it. Before we get to the jury, I want to ask a question about those confessions in the newspapers that almost nobody asks. How did they get there? A confession taken by police in a murder investigation is not a public document. It is evidence. It sits in a prosecutor's file. Reporters in 1927 did not have subpoena power, and they could not walk into the district attorney's office in Queens and photograph whatever they liked. For the full text of both confessions to appear in the papers within days, somebody with lawful custody of those documents handed them over. I cannot tell you who, and I am not going to guess at a name. What I can tell you is the category of person it had to be. It was somebody inside the machinery of the prosecution or the police, and whoever it was did it knowing exactly what it would do. And consider what it did do, in order. It convicted both defendants in public, 5 weeks before a jury was sworn. It made the pool of available jurors, in that county, into people who had already read the evidence and formed a view. It gave the tabloids the raw material for the characters they built. And it removed, permanently, any possibility that either defendant's story could be tested first, in a courtroom instead of a newsroom. There is a reason prosecutors are not supposed to do this. It is not politeness. A trial is only worth running if the answer is not already fixed, and the fastest way to fix an answer is to publish the evidence before anybody is allowed to argue about it. The leak was, in practical terms, the most consequential procedural event in this entire case, and it happened before the case formally existed. It has no citation. It appears in no opinion. No appellate court reviewed it, because there was nothing on the record to review. That is worth holding on to, because it is a general truth about how records work. The things that get examined later are the things that happened on paper, in a courtroom, in front of a stenographer. The things that decide cases often happen somewhere else entirely, and leave nothing behind for anybody to find. The Court of Appeals could review the severance motion because the severance motion was written down. Nobody could review the leak. It was a conversation. Now I have to tell you who was going to decide it, because the composition of that jury is a fact about this case that almost never gets mentioned, and once you have it, you cannot unsee it. 12 men, not 12 people. 12 men, and that was not an accident of the draw. In the state of New York in 1927, a woman could not sit on a jury. She could vote. New York women had been voting in state elections for a decade by then, and in federal elections since the amendment. Ruth Snyder was a citizen with a ballot. She could help choose the governor who would later decide whether she lived. She could not be judged by anyone who shared her position in a household. Women in New York would not become eligible for jury service for another 10 years. So the panel that heard a case about a marriage, about what a wife owed a husband, about whether a woman had been a schemer or a victim of one, was drawn entirely from men who went home to wives. I am not suggesting a jury of women would have acquitted her. I have no idea, and neither does anybody else. And the honest answer is that the evidence was strong enough that a jury of anybody would probably have convicted her. But look at the shape of what the state was asking those 12 men to do. It was asking them to compare two accounts of the same bedroom, one from a woman describing a marriage, one from a man describing a woman. And it had assembled a panel that could evaluate the second kind of testimony from the inside and the first kind only from the outside. When it was over, and the governor had refused to spare her, the New York Times wrote an editorial about it. The argument it made was that equal suffrage had put women in a new position, and that if women were equal with men before the law, then they had to pay the same penalties as men for breaking it. Hold that sentence up to the light. It is not a cruel sentence. On its face, it is a sentence about equality, and it was written by people who thought they were being fair. But look at what it does. It reaches for the vote, which women had won, in order to justify the chair. It does not mention that the same women who had won the ballot were still barred from the jury box. Equality was invoked at the exact moment it cost her something, and it had been unavailable at every moment it might have helped. That is the whole century in one editorial. The last thing I need to give you before the courtroom is the piece of this case that gets skipped most often. It is the piece that turns Ruth Snyder from a tabloid character back into a defendant. She knew. She and her lawyers understood exactly what the room was going to do to her. They were not naive about it. Edgar Hazelton and Dana Wallace were experienced criminal lawyers, and they could see the arithmetic as clearly as I have just laid it out for you. They knew that the single most dangerous document in the world, as far as their client was concerned, was Judd Gray's confession. They knew it could not be used against her in a trial of her own, and they knew that it would be read aloud, in full, in a trial where she and Gray sat side by side. So they filed the motion. They asked Justice Townsend Scudder for a separate trial for Ruth Snyder. They were not asking for a favor. They were asking for the thing that would have made the trial legally clean. If she were tried alone, the state would still have had her confession, the knots, the mattress, the windows, the policy, and the forged signature. It would almost certainly still have convicted her. But it would have had to convict her on evidence that the law actually permitted against her. And Judd Gray's lawyers stood up and opposed that motion. Think about what that means for a second, mechanically, setting aside how it feels. Judd Gray needed the joint trial too. His entire defense was that Ruth Snyder was the author of the crime, and he was an instrument of it. To sell that, he needed her sitting next to him. He needed the jury looking back and forth. He needed his account of her to be heard by the same 12 men who would judge her, so that his story about being swept along had a visible woman to be swept along by. Separate her, and he is just a corset salesman from out of town who brought a window weight to a house in Queens and swung it. So both defendants wanted opposite things, and one of them wanted the same thing as the prosecutor. The state of New York and Henry Judd Gray on the same side of a motion against Ruth Snyder, and they won. The judge denied the motion. Under the amendment of 1926, that was entirely within his discretion, and he exercised it, and the case was set down for one trial with 2 defendants. Here is the sentence I want to leave you with before the courtroom, and I want it to sit heavily. The state of New York never had to choose between those 2 confessions. It never had to decide which of them was telling the truth about that bedroom. It never had to build a case that survived on its own against either one of them. It got to have both. All it needed was one room, one jury, and one judge willing to say yes. The trial of Ruth Brown Snyder and Henry Judd Gray opened on the 27th of April, 1927, in the Queens County Courthouse at Long Island City, before Justice Townsend Scudder. It ran until the 9th of May, 13 days. I want to start with the building, because the building tells you what kind of proceeding this was going to be. people queued for seats. Not a handful of relatives and a few reporters. Crowds, in the street, in the morning, for a place inside a courtroom in Queens. Police had to open lanes to walk the jurors through. Society figures came. Writers came. The seats in that room became a commodity. People who had no connection to Albert Snyder, or to anybody who had ever met him, stood outside in April weather for the chance to sit down and look at a woman. A representative of the Salvation Army turned up at the Queens County Jail to deliver Bibles to the two defendants. That is in the photographic record. Somebody photographed her trying, and the press gallery was not a press gallery in any sense we would recognize. The papers did not simply send reporters. They staffed the trial the way a network staffs a championship. Novelists were hired to write about it. Playwrights, clergy. A newspaper hired a phrenologist to examine the shape of the defendants' heads and explain their souls to the readership. Damon Runyon was there, and Runyon gave the case the name that stuck. He called it the dumbbell murder. He meant it as an insult to the intelligence of the crime, and he was right about that. It was a stupid murder. It was planned by two people who thought a must hotel bed and a mailed letter would hold, who left the stolen jewelry in the house, who staged a burglary in a building they had not bothered to break into. Runyon was a professional, and the professional judgment was correct. But look at what the name did. The dumbbell murder. It is a funny phrase. It invites you to feel superior to the people in the dock. And a case with a funny name is a case you do not think very hard about. That turned out to matter. The most serious legal question in the entire proceeding had already been decided in a motion nobody had bothered to write a joke about. Before the evidence, one piece of law, because without it, you cannot see what the insurance was doing in that courtroom. Murder in the first degree in the state of New York in 1927 was not simply killing somebody. It required a killing from a deliberate and premeditated design to take a life. Deliberation and premeditation. Those two words were the difference between the chair and a term of years. So the state did not merely have to prove that Ruth Snyder had been part of her husband's death. It had to prove she had planned it in advance, coolly, with intention. Now think about what the strongest possible evidence of advance planning would look like. Not a witness. Witnesses forget and shade and get cross-examined. You would want a document, dated, signed, filed with a company, paid for in installments over months out of household money. A life insurance policy with a violent death clause is the single most premeditated object a person can own. That is why the paper mattered more than the sash weight. The weight proved a killing, the policy proved a design, and the policy had been sitting in a drawer, accruing its own quiet evidentiary weight, month after month, while she paid the premiums. Every payment was a sentence in a confession she had not yet written. The jury took days to seat, and the reason it took days is the reason this whole story exists. Every man who came into that courtroom for questioning had read the newspapers. That was not a suspicion. It was arithmetic. Both confessions had been printed in full in a city where the Daily News alone was the best-selling paper in America 5 weeks earlier and had been chewed over daily ever since. So the examination of prospective jurors could not possibly ask whether they had heard about the case. It had to ask something much weaker. Whether, having read the confessions, they could set aside what they had read and decide the matter on the evidence. Men said yes. Men always say yes. It is not usually a lie either. People genuinely believe they can do it. 12 of them were eventually sworn. I cannot tell you much about who they were as individuals. The record of ordinary jurors in 1927 is thin, and I am not going to fill a gap with invention. What I can tell you is the category. They were men, because the law of New York permitted no alternative. They were drawn from Queens County, which is to say from the same suburban world the Snyders lived in, the world of new houses and card parties and commuting. That last part cuts both ways, and I want to leave both edges showing. It meant they understood the setting exactly. They knew what that street looked like on a Saturday night. They knew what it cost to keep a house like that. It also meant that the crime in front of them was a crime against the specific arrangement their own lives were built on. A wife had killed a husband in a bedroom in a house exactly like theirs, over money, with the help of a salesman who came to the door. You do not have to believe those 12 men were biased to see the problem. You only have to notice what they were being asked to be impartial about. Now let me take you through what the state actually did, because the prosecution of Ruth Snyder was, in the narrow sense, competent and fair. Richard Newcomb was the district attorney of Queens County, and he built his case the way you would want a case built. He did not open with the affair. He opened with the house. He put the scene in front of the jury. The absence of forced entry, the condition of the drawers, the loose knots, the undamaged woman. He established that the jewelry reported stolen had been recovered from beneath a mattress in the bedroom of the woman who reported it stolen. He put in the insurance, the policies, the amounts, the double indemnity provision, and the fact that Albert Snyder had not applied for the largest of them. He established how the paper had been produced and the role of the agent who produced it. He put in the medical evidence, the head injuries, the wire, the chloroform, and then Newcomb did something that I think was the most quietly devastating move of the trial, and it had nothing to do with either defendant. He proved the signature. Albert Snyder's name was on that policy. The state established that Albert Snyder had not put it there. That meant somebody had, and it meant an insurance company had accepted it, and it meant an agent had processed it. The man who handled that paper was eventually dismissed by his company and went to prison for forgery. I want to be careful about what that does and does not prove. It does not prove Ruth Snyder forged her husband's name with her own hand. What it proves is that the policy was not a document Albert Snyder participated in. He was not insured. He was inventoried. And it proves something about the machinery around her, which almost never gets said about this case. Ruth Snyder did not do this in a vacuum. To turn a living man into a violent death payout, she needed an industry that would write the paper, an agent who would take it, and a company that would accept a signature nobody checked. All three of those existed, and all three of them cooperated, and only one of them was ever going to sit in that dock. The agent went to prison for forgery. The company kept the premiums until there was a reason not to. And then he read the confessions. I want you to picture the mechanics of that, because this is the hinge of the whole night, and it happened in the most undramatic way imaginable. A document was read aloud in a quiet room by a man in a suit. Ruth Snyder's confession was read. In it, she admitted the affair, admitted knowledge, admitted the policy, and placed the killing on Judd Gray. There are photographs of her in the witness stand, while her own words were read back into the room. Then Judd Gray's confession was read, and every man on that jury heard a detailed, first-person, sworn-out account of Ruth Snyder planning the death of her husband, pressing him to do it, threatening him, and taking part in the killing herself. That account was not evidence against her. As a matter of law, it was evidence against Judd Gray and nobody else. Justice Scudder would in due course tell the jury as much. It was the most important thing said about her in the entire trial. She had asked, before any of this began, not to be in the room while it happened. The request had been denied, and so she sat there at a table in front of 12 men and a gallery of novelists. The man she had been sleeping with described her, in his own words, as the author of a murder, and a judge prepared to explain to the jury that they should not hold it against her. Sit with that for a moment. Then the defense case is opened, and this is where the structure of the room stops being an abstraction and starts doing visible damage. Both defendants testified. That was a choice, and it was close to a forced one. When two people in the same dock are each blaming the other, silence is fatal. If Ruth Snyder had stayed off the stand while Judd Gray told his story would have stood in the room unanswered. If he had stayed off while she told hers, the same. So both of them got up, and both of them swore to tell the truth, and both of them told a story that could not be reconciled with the other. Ruth Snyder testified that her confession had not been voluntary. She said it had been obtained by pressure that, in the state she was in, she had not been able to withstand. Remember the conditions of that room in Queens Village. No lawyer. Hours of questioning. A woman who had not slept, whose husband was dead upstairs, whose daughter had found her on the floor. That claim was not absurd on its face. In a courtroom in 1927, it was also close to useless, because the protections that would have given it teeth did not exist yet. She testified that she had tried to talk Judd Gray out of it, that she had believed she had succeeded, that she had not been present when the blows were struck, that when she understood what was happening, she had tried to stop him while he was doing it. Judd Gray testified that she had arranged the plan and that she had jointly taken part in the actual killing. Two people, under oath, in one room, describing one bedroom irreconcilably. Now watch the cross-examinations, because this is the part I most want you to hold on to. In an ordinary trial, a defendant who testifies faces one hostile examiner, the state. That is the deal. You give up your silence and you submit to the prosecutor's questions. Ruth Snyder faced two. She was cross-examined by the district attorney of Queens County, whose job was to prove she was guilty. And she was cross-examined by counsel for Henry Judd Gray, whose job was to prove she was guiltier. Those are not the same job, and that is exactly why it was so effective. A prosecutor has to be careful. He has institutional restraints. He has an appellate record to protect, and he has to maintain the appearance of even-handedness, because he represents the state against both defendants. Gray's lawyer had no such problem. He represented one man, and every inch of blame he could move onto the woman at the next table was an inch off his client. He was free to be as hostile as he liked. He was, functionally, a second prosecutor sitting inside the defense. And the same was true in reverse. Judd Gray was cross-examined by the state and by Hazelton and Wallace for Ruth Snyder. So this was not one trial with two defendants. It was three cases running at once in a single room. The state against both of them. Ruth Snyder against Judd Gray. Judd Gray against Ruth Snyder. I said earlier that I would give you the strongest version of the argument for joint trials, and I did. Now I want to be scrupulous about it. This is precisely the place where the good argument shows its edge. The honest case for the joint trial is that the jury sees the whole event, That is real. Those 12 men did see the whole event. They saw both accounts stand up next to each other, and they saw both accounts fail under pressure. They were far better placed to know that both of these people were lying about their own share. Better placed than any single jury hearing one of them alone. Something true came out of that room. I am not going to pretend otherwise. But notice what the truth that came out was. It was the truth that both of them were guilty. That is what a joint trial is excellent at producing, when both defendants are in fact guilty and are in fact lying. What that room could not do, structurally, was produce an acquittal for either of them. Not because the evidence forbade it, because the architecture did. Each defendant's best available strategy was to convict the other. Each was the most credible witness available against the other, and neither could attack the other without confirming the central fact, which was that a murder had been committed by the two people at that table. Every move either of them made narrowed the room. She could not say she was innocent without accusing him, and accusing him meant admitting she had been there and had known. He could not say he was innocent without accusing her, and accusing her meant admitting he had carried a sash weight into a bedroom. There was no configuration of that trial in which anybody walked out. And I want to be careful and precise about what I am claiming, because this is the kind of sentence people misquote. I am not saying Ruth Snyder deserved an acquittal. I have told you twice already that she did not, and I will say it again now. She helped kill a sleeping man for an insurance payout and lied to police about it within hours. I am saying that the room she was tried in was not capable of testing whether she deserved one. It was only capable of confirming what everybody had already decided in March, when the confessions ran in the papers. A trial is supposed to be an instrument. You put a question into it, and it gives you an answer, and the answer is worth having because the instrument could have gone the other way. When the instrument cannot go the other way, it is not measuring anything. It is a ceremony. That is the difference between a verdict and a conclusion, and it is the whole reason I do this. Now, the closing arguments and the charge. The summations took the shape you would now expect, and there were 3 of them, which is itself the point. Newcomb summed up for the state against both defendants. Then counsel for Judd Gray summed up, and a substantial part of that summation was an argument that Ruth Snyder was the guilty party. Then counsel for Ruth Snyder summed up, and a substantial part of that was an argument that Judd Gray was. So the jury, in the final hours before it went out, heard the case against Ruth Snyder argued twice. Once by the prosecutor of Queens County, once by a defense lawyer. And it heard the case for Ruth Snyder argued once, by her own lawyer, who had to spend part of his time attacking a co-defendant instead of the state. Count the voices in that room at the moment it mattered most. 2 lawyers arguing she was guilty, and 1 lawyer arguing she was less guilty than the man beside her. Nobody in that room, at the end, was making the simple argument that the state had failed to prove its case, because her own counsel could not afford to. He had to spend his closing on apportionment. That is what the denied motion cost her, in the most literal and countable way I can express it. It cost her the exclusive use of her own defense. There is one more thing that never happened in that trial, and I want to name it because its absence is loud. Nobody ran a serious coercion defense for Ruth Snyder. Judd Gray ran one. His whole case was that he had been dominated, worked on, hypnotized, threatened with exposure to his wife. He had a story in which a stronger will overcame a weaker one, and the papers loved it, and the jury at least had to consider it. The mirror image of that story was available to her and was never really built. She had been married at a young age to a considerably older man who kept his dead fiancé on the wall. She had no legal exit from that marriage. She had a lover who was a traveling salesman with a taste for drink and a wife at home. There is a version of the defense in which she is the one who was worked on. I am not saying that version is true. I genuinely do not know, and the record does not settle it, and both of these people lied under oath about the most important minutes of their lives. I am saying that only one of them got to tell that story. And the reason is not that the evidence forbade the other one. It is that by the time 12 men sat down, the city had already spent 5 weeks deciding which of these two people was the strong one. The tabloids used her hair and her parents and the shape of her skull to decide it. The domination defense was taken. She could not have it. It had already been assigned. Justice Scudder's charge to that jury was, I think, the most quietly remarkable document in the case, because he told them the truth about their situation. He told them that their task, faced with two people who had both confessed and who each accused the other, was to decide who had done what. Then he laid the two accounts out for them. He reminded them that Gray had testified that Ruth Snyder arranged the joint plan and jointly participated in the actual killing, and he reminded them of her testimony, that Gray was determined to take the life of Albert Snyder, that she had endeavored to prevent him from doing so, that she was not present at the time Gray struck the blows, and that she believed she had dissuaded him from his purpose. That is the judge, in his own words, handing the jury a choice between two stories. Read that again, slowly, and notice what is missing. He did not tell them that Gray's account of her was not evidence against her, not in that passage. In that passage, he set the two accounts side by side as the material the jury was to work with, and asked them to decide who had done what. Now, I want to be fair to Townsend Scudder, because this is the moment where it would be very easy to hang a man who does not deserve it. A charge to a jury in a murder trial is long. It goes on for a considerable time, and it covers the elements of the offense, the burden of proof, the presumption of innocence, and the limits on the use of evidence. The full charge in this case will have contained the standard instruction on confessions, because it had to. And because the highest court in New York later reviewed the whole record and found no ruling the defendants could reasonably complain of. If that instruction had been missing, that is the first thing they would have found. So the instruction was almost certainly given, and it did not matter. That is my point, and it is a much darker point than a claim that a judge got something wrong. The judge did his job. The prosecutor did his job. The instruction was given. The record was clean. The appellate court checked and found the ruling sound. And a jury of 12 men still spent 100 minutes deciding between two stories, exactly as the judge had framed it, in a room where one of those stories came from a co-defendant whose account was not supposed to count against her. The system did not fail. The system ran correctly and produced this. The jury went out. 100 minutes later, they came back. 1 hour and 40 minutes. I told you at the start what you can do in 100 minutes, and I am not going to repeat the list. I want to give you a different comparison instead. They had sat through 13 days of trial, 2 confessions, 2 defendants testifying and being cross-examined twice each, medical evidence, insurance documents, a forged signature, a staged crime scene, closing arguments from 3 separate sets of lawyers, a full charge on the law of first-degree murder in the state of New York, and they resolved all of it for 2 human beings in less time than the trial spent on some single afternoons. That is not an argument. That is arithmetic. And arithmetic, unlike testimony, does not have to be cross-examined. Both defendants were found guilty of murder in the first degree. Ruth Snyder wept in her seat. Judd Gray, his face flushed, looked hard at the jury. The account that comes down to us says, he looked at them without animosity. I find that detail almost unbearable, and I have no way to interpret it, so I am going to leave it exactly where the record leaves it, which is as a description of a man's face. Justice Scudder set sentencing for the following Monday, which was a formality, because in the state of New York in 1927, there was only one sentence available for murder in the first degree: death by electrocution. The date was set for the week of the 20th of June, 1927, 3 months after Albert Snyder died in his bed. That date came and went because of the appeals, and the appeals are where this story stops being a tabloid sensation and becomes something that I think belongs in the permanent record of American law. There is one more person in that courtroom I have not mentioned, and I have avoided her on purpose until now, because she is the part of this file I find hardest to read. Lorraine Snyder was 9 years old. She had found her mother tied on the hallway floor on the morning of the 20th of March. She had been sent to fetch the neighbors. Her father was dead upstairs, and her mother was going to be convicted of killing him, and by the end of the year she would have neither parent. She was also, and this is the detail that makes the whole thing turn, the person with a legal claim to her father's life insurance. Hold that, we are going to need it. A 9-year-old girl was the beneficiary of the consequence. The policy had been written to convert her father's violent death into money. It was going to be argued about in courtrooms after both of the people who killed him were dead. And the argument was going to be about her. Photographers waited for her. There is a photograph in the archive of the elevators at the Queens County Courthouse, taken while Lorraine was in them. That is the level of attention we are talking about. A newspaper thought a picture of the lift doors was worth taking, because a 9-year-old was on the other side of them. But before we go up to the Court of Appeals, I want to close this part of the night with the thing that has stayed with me longest out of the whole file, and it is not the verdict. It is a small procedural fact. At some point in those 13 days, Ruth Snyder's lawyers made their motion again. Lawyers do that. When you have been denied something before trial, and the trial then does to your client exactly what you predicted it would do, you renew the application, because you are building a record for the court above. They had said, before the trial, that a joint trial would deny her a fair one. Then they sat in the room and watched Judd Gray's confession read aloud to her jury. They watched Gray's own lawyer cross-examine her as a hostile witness. They watched the judge frame the jury's task as choosing between her account and his. Everything they had warned about happened, in order, in front of them, and there was nothing left to do about it except write it down carefully so that somebody in Albany would read it. They wrote it down carefully, and somebody in Albany read it. That is the part almost nobody knows, and it is the part I have been building toward all night, because the highest court in the state of New York picked up this file. 2 confessions, a forged policy, jewelry under the mattress, unbroken windows, and it did not treat the severance question as a technicality raised by a desperate lawyer. It treated it as the only thing in the case still worth arguing about. And then it let her die anyway. The case went up to the Court of Appeals of the state of New York, which is the highest court in New York and one of the most respected courts in the country. The citation is People Against Snyder, volume 246 of the New York Reports, page 491. The year is 1927. I am going to read you what that court did with this file, because it is short and because I do not think I can improve on it. The court began with the shape of the case. The defendants were jointly indicted. Mrs. Snyder moved for a separate trial. The defendant, Henry Judd Gray, joined with the state in opposing the motion. It was denied by the trial judge, and the defendants were thereafter tried together, and both were convicted of murder in the first degree. Then it said that an extended analysis of the testimony would serve no serious purpose. Think about that sentence for a moment. This was the most heavily reported trial in America. 13 days, 2 confessions, a forged insurance policy, a staged burglary, a phrenologist, and the highest court in New York looked at the evidence and said, in effect, there is nothing here to argue about. Then it explained why. They have been found guilty upon evidence which is clearly sufficient, the court wrote, after a trial in which no rulings have been made of which they may reasonably complain. Clearly sufficient, no rulings to complain of. And then came the sentence that I have not been able to get out of my head since the first time I read it. The only question which remains for consideration, the court wrote, is whether the denial of Mrs. Snyder's preliminary motion for a separate trial resulted in depriving them or either of them of a fair trial. The only question, out of everything, out of the whole enormous, sensational 13-day American spectacle, the highest court in the state of New York identified exactly one issue that it considered still open, and it was the motion. It was the ordinary procedural motion that had been denied without ceremony before the trial began. It was the thing Ruth Snyder's lawyers had been shouting about from the start, while the newspapers were busy hiring a man to measure her skull. They were right. The court agreed with them about what the real question was. Now watch what happened next. The court turned to the statute, and this is where you cash in that third thing I asked you to carry. 1926. Section 391 of the Code of Criminal Procedure, as recently amended, the court wrote, by the laws of 1926, Chapter 461. It provided that defendants jointly indicted may be tried separately or jointly in the discretion of the court. And then the Court of Appeals wrote this: it may be assumed that the legislature did not intend to leave arbitrary choice to the court. Read that again, slowly, because it is one of the most revealing sentences a court has ever written about its own predicament. It may be assumed. That is not a finding. That is a court looking at a sentence a legislature wrote. It sees that the sentence hands one judge an unreviewable choice with no standard attached. It understands perfectly well that this cannot be what a decent system means, and it has nothing in the text to point at. So it assumes, it supposes, that surely somebody must have intended a limit, because the alternative is intolerable. The words on the page did not say what the words on the page ought to have said, and the court, having noticed that, went on to apply them. It affirmed the convictions. Both of them. The sentence of death stood. Judd Gray took his own run at it, on the same ground, from the other side. His lawyers sought a writ of habeas corpus, arguing that his constitutional rights had been violated because he had been tried jointly rather than in a trial of his own. Which is worth sitting with for a second, given what he did in April. In the spring, Judd Gray's lawyers stood up beside the prosecutor and argued that the two of them should be tried together, because the joint trial was where his story worked. In the winter, with a date set, the same man argued that the joint trial had violated his constitutional rights. I am not going to call that hypocrisy, because I do not think it is a moral failing, so much as a description of what a joint trial does to the people inside it. It turns every strategic decision into a bet, and it makes the bet irreversible. He bet on the room. He lost, and then he argued that the room was unconstitutional. He was correct about the room. He was correct 40 years too early, and he had helped build it. The petition was dismissed. Then there was one more application, and this is the one I have been saving all night, because this is where the word comes apart. Somebody applied for a stay of Ruth Snyder's execution on the following ground: that she was a necessary witness in a civil suit. The civil suit was an action to force 3 insurance companies to pay out the benefits of Albert Snyder's life insurance to his daughter Lorraine. Let me say that again, plainly, and then let it sit. There was a lawsuit going on about who got the money. The 9-year-old girl who had found her mother tied on the hallway floor was the claimant. The companies did not want to pay, and the person who knew more than anybody alive about how those policies had been created, who had paid the premiums, who had watched the signature go onto the paper, was sitting in the death house at Sing Sing. So an application was made to keep her alive long enough to testify about the insurance. It was dismissed. Indemnity, to be made whole, to be restored to the condition you were in before the loss. That is what the word means, and I asked you to hold it at the very beginning, and here is what it turned into. The policy was written to make Ruth Snyder whole. It was written so that a violent death would restore her, doubled. She killed a man to trigger it. She was never paid a cent of it. The daughter left behind had to sue 3 companies for it, and the one witness who could have explained the document was killed by the state before anybody could ask her. Nobody was made whole. Not one person in this entire file was restored to anything. The only thing in the story that behaved exactly as designed was the piece of paper. The last door was the governor. Alfred Smith was governor of New York, and clemency was his to give. There was public pressure in both directions, and a great deal of it, because a large part of the country had decided that whatever else was true, you did not put a woman in the electric chair. He refused. And when he refused, the New York Times ran the editorial I read to you earlier, the one that reached for equal suffrage to explain why she had to die. If women were equal with men before the law, it said, they must pay the same penalties as men for transgressing it. She had the vote. She could not sit on the jury that judged her, and when the state came to kill her, her equality was the reason given. There were 9 months between the verdict and the chair, and I want to account for them, because the way that time was spent tells you what this case had become. She was held at Sing Sing. The execution date, first set for June, came and went, while the appeals ran. She waited through the summer of 1927 and the autumn and into the new year. Letters arrived, a great many of them. That is well attested, and it is one of the strangest features of the whole affair. Some were from people who wanted her to die and said so in detail. Some were proposals of marriage, which is not a joke and is documented in the coverage of every notorious condemned woman of that era. Some were from women who had read the trial reports and recognized something in the marriage. And there was a public campaign to save her, and it was substantial, and it was not primarily an argument that she was innocent. It was an argument that the state should not electrocute a woman. I want to be precise about that, because it is the exact place where the sympathy of 1927 fails to be useful to her. The people writing to Albany were not saying the trial had been unfair. Almost nobody was saying that. They were saying that womanhood itself was a reason for mercy, which is a claim about her category rather than her case. So both sides of the public argument about Ruth Snyder were arguments about what kind of creature she was. The papers said she was a vampire and therefore deserved it. The petitioners said she was a woman and therefore did not. The one thing that had actually gone wrong, the room, had no constituency at all. It lived in a brief filed by 2 lawyers in Long Island City and in a paragraph of a court opinion in Albany that nobody outside the profession would read for the better part of a century. Governor Smith had that paragraph available to him. He had the Court of Appeals decision saying the severance question was the only question in the case. He refused clemency anyway, and I have seen no evidence that the room was ever the thing anybody asked him about. The date was the 12th of January, 1928. Sing Sing Prison at Ossining on the Hudson. Now I have to tell you about the photograph. The New York Daily News wanted a picture. That is the beginning and the end of the motive, and I want to resist making it more complicated than it was. The Daily News had built itself on photographs. Its publisher was Joseph Medill Patterson. A woman was going to be executed at Sing Sing for the first time in nearly 30 years, and he wanted an image of it on his front page. There were 2 problems. Cameras were forbidden in the execution chamber, and the guards at Sing Sing knew every photographer the Daily News employed by sight. So Patterson telephoned his cousin. His cousin was Robert McCormick, who ran the Chicago Tribune. McCormick agreed to lend him a man. The man was Thomas Howard, a Tribune photographer. And the reason Howard was useful was simply that nobody at Sing Sing had ever seen his face. Howard practiced for a month. I want you to hold that, not the execution, the rehearsal. For roughly 4 weeks, in a hotel room in New York, a professional photographer trained himself to take one photograph without using his hands. He had a small camera, a modified miniature plate camera, and he strapped it to his lower leg, above the ankle, under his trousers. He ran a shutter release cable up the inside of his leg and into his pocket. Then he practiced lifting the fabric of his trouser leg and pressing the release over and over until he could do it in a room full of people without being seen doing it. On the night of the 12th of January, 1928, he walked into Sing Sing on press credentials as a journalist. He was not recognized. He took his place with the other witnesses. At 11:06, the current was applied to Ruth Snyder, and a man in the second row lifted his trouser leg and pressed a cable. Judd Gray was brought in after her and executed in the same chair. The accounts of the interval disagree. Some say 6 minutes, some say 10, and the paper's own caption puts both of them dead by 11:14. I am not going to pick one, because it does not matter, and because guessing would be the wrong instinct. A few minutes. Long enough to clear the room and reset the machine. There are words attributed to Ruth Snyder from that room. The Daily News printed them, and they have been repeated for a century since, and they are a plea for forgiveness for the people doing it. I am not going to read them to you as fact. Here is why. The only reason we have them is that they were printed by the same newspaper, in the same edition, that was at that moment selling the photograph of her death. That newspaper had a month-long investment in this night, and an enormous commercial interest in how the scene played. The witnesses were journalists, in a room where nobody was permitted to take notes on the record. I am not saying the words are invented. I have no evidence of that. I am saying they come to us from an interested party in a controlled room, and a careful person grades that source accordingly and moves on. What is not in dispute is the front page. On the 13th of January, 1928, the New York Daily News ran an extra edition. The headline was one word: dead. Underneath it was the photograph. Her body in the chair, the helmet on her head, her face covered, an electrode strapped to her bare right leg. Visible beside the chair, in the frame, is the table on which her body was going to be wheeled to the autopsy room. The extra edition sold roughly 500,000 copies above the paper's ordinary daily circulation. It sold out. There were other editions printed that day without the photograph, and those are the ones that survived on the shelves, because the one with the picture went first. 500,000 people in one city in one day going out and buying an extra copy of a newspaper because there was a photograph of a woman being killed inside it. Thomas Howard was paid $100 extra for the picture. Prison officials were furious. They talked about bringing charges against Howard and against the paper. Nothing came of it. And I want to give you one more detail about that photograph, because when I found it, I had to put the file down for a minute. The original print is tiny. It is about 1 3/8 inches by 2 1/8 inches, smaller than a playing card. It is that small because it is a contact print made from the negative of a camera that had been strapped to a man's shin, and nobody enlarged the original. The most famous execution photograph in the history of American journalism sold 500,000 extra newspapers. It is still reproduced in textbooks a century later, and it exists as an object roughly the size of 2 postage stamps side by side. The camera survived too. The Daily News kept it, and in 1963, the paper donated it to the Smithsonian Institution. Thomas Howard had died 2 years before that. The camera is in the National Collection of the United States, cataloged, preserved, and available to be looked at by the public. The camera that photographed her is a museum object with a record number. So is the front page. Now let me clean up 2 things in the record, because I have been careful with you all night, and I am not going to get sloppy at the end. The first is the counting. You will see it said that Ruth Snyder was the first woman executed in New York, or the 3rd, or the 8th. Those numbers are all in print, in reputable places, and they conflict, because they are counting different things. Some count executions in the state, under any method. Some count only electrocutions. Some count only Sing Sing. What is solid is this. She was the first woman put to death at Sing Sing since Martha Place in 1899, nearly 30 years. That is why the papers wanted the picture. The second is the fiction, and it is the reason most people have brushed against this case without knowing it. The clause in that policy was called double indemnity. That is not a screenwriter's phrase. That is the insurance industry's own term for a provision that pays twice for a violent death, and it was in the paperwork in a drawer in a house in Queens Village in 1927. A bored wife, an ordinary man in a commercial trade, a husband worth more dead, a clause that pays double. That became the spine of the hardest American crime fiction of the following decade, and the films made from it are still the ones people name when they name the genre. The names of the people were changed. The name of the clause was not. Which means that for about 100 years, most of the audience for this story has encountered it, with the insurance intact and the trial removed. They kept the policy, they dropped the courtroom, and the courtroom was the part that should have kept us all awake. Because here is the last thing. And this is the reason I picked up this case in the first place, and I have been holding it since the beginning. Ruth Snyder's lawyers were right. Not morally right, not right about her innocence. She was guilty, and they almost certainly knew she was guilty. They were right about the law, and it took the United States of America 40 years to catch up with them. On the 20th of May, 1968, the Supreme Court of the United States decided a case called Bruton against the United States. Two men had been tried together for an armed robbery of a post office. One of them, a man named Evans, had confessed, and his confession implicated the other man, Bruton. The confession was admitted at their joint trial. The trial judge did everything correctly. He admitted it only against Evans. He instructed the jury, carefully and clearly, to disregard it entirely in deciding whether Bruton was guilty. The Supreme Court threw the conviction out. Justice Brennan wrote the opinion, and the holding is this: there was a substantial risk that the jury, despite instructions to the contrary, looked to the incriminating statements in determining the defendant's guilt. Because of that risk, admitting the co-defendant's confession in that joint trial violated the defendant's right of cross-examination under the Confrontation Clause of the Sixth Amendment. The instruction was not enough. It had never been enough. The court said so out loud, and in saying it, overruled its own decision from 11 years earlier, which had held the opposite. That is the exact argument Edgar Hazelton and Dana Wallace made in a courthouse in Long Island City in the spring of 1927. Their client had asked to be tried alone because she knew that a jury, which heard her lover's confession, would use it against her no matter what a judge told them. She was denied. She was tried in the room. The confession was read. The instruction was given. She was convicted in 100 minutes and killed 9 months later. 40 years and 4 months after the current went through her, the highest court in the country held that the room she died in could not produce a fair trial. And I want to tell you the most devastating detail in that 1968 decision, which is not in the majority opinion at all. It is in the dissent. One of the dissenting justices objected that there had been no new learning since the earlier case to suggest that juries were any less reliable than they had previously been considered to be. No new learning. He meant it as a criticism of the majority for changing the rule without new evidence. But read it the other way, and it is the whole point. And it is an accidental confession by the American legal system about itself. Nothing new had been learned. Nothing new needed to be learned. There was never a moment when anybody with a functioning mind believed that 12 people could hear a confession and then unhear it. Ruth Snyder's lawyers knew it in 1927. The Court of Appeals of New York half admitted it in 1927, when it looked at a statute handing one judge an unreviewable choice and had to assume the legislature could not have meant that. The knowledge was available the entire time. What was missing was not learning, it was willingness. And there is one more piece, and it lands on the other half of her defense. 4 years before Bruton, in 1964, the Supreme Court decided a case called Jackson against Deno. It struck down the procedure a state had been using to handle a defendant's claim that a confession was not voluntary. The state was New York. Ruth Snyder testified at her trial that her confession had not been voluntary. She said it was taken from her under pressure she could not withstand, after hours of questioning without a lawyer, on the day her husband's body was carried out of the house. Both of her arguments were eventually vindicated by the highest court in the United States. Both of them. the joint trial, and the confession. She was still guilty. That has not changed, and it will not change, and I am not offering it as a rescue. But she was tried in a room the country later admitted could not do the job. On a confession taken by a procedure the country later admitted was unconstitutional. And the reason nobody looked closely at the time is that she had been converted into a character before the trial began. A synthetic blonde, a vampire wife, the Viking ice matron of Queen's Village, a skull to be measured by a man a newspaper paid. You cannot examine the machinery when everybody is looking at the woman. That is what the tabloids were actually for. Not lying, directing attention. Before the ledger closes, I owe you an accounting of what this file does not settle, because a case is not honestly told until somebody says out loud where the record stops. We do not know which of them struck the fatal blow, or whether the phrase even applies to a death caused by 3 overlapping methods. The 2 people who were in the room both testified, both lied, and both had the strongest possible reason to lie in exactly the direction they lied in. The medical evidence establishes what killed him. It cannot establish whose hand did which part. Anybody who tells you the record settles the apportionment is telling you something the record does not support. We do not know whether her confession was voluntary in any sense a modern court would accept. She said it was not. The state said it was. The procedure that existed to resolve that dispute in New York was the procedure the Supreme Court eventually struck down. We do not know who handed both confessions to the newspapers. We do not know how many earlier attempts on Albert Snyder's life there really were, if any. We have Judd Gray's number, given by a man bargaining for his life. We do not know what Lorraine Snyder was eventually paid, or what happened to her, and I have chosen not to go looking very hard, because she was 9, and she did not consent to any of this. And we do not know, and can never know, what Albert Snyder thought about his marriage. He is the only person at the center of this story who never gave a statement. Everything anybody has ever written about the inside of that house comes from the 2 people who killed him. That is the largest silence in the file, and it is worth naming, because he keeps getting turned into a prop in an argument about her. He was a man who laid out pages of a boating magazine and could not stop grieving a woman who had died a decade before him. He was killed in his own bed by his wife and a corset salesman. And the last 100 years have mostly discussed him as a motive. So here is where the ledger closes. Albert Snyder died in his bed on the 20th of March 1927, killed by his wife and her lover with a window weight, a chemist's bottle, and a length of picture wire. He never knew a document existed that priced his violent death. Nobody speaks for him in this file, because he never got to give a statement about his own marriage, and the only accounts of it come from the 2 people who killed him. Ruth Snyder asked for a trial of her own. The state of New York and the man she was accused with joined forces to refuse her. A judge exercised his discretion under a statute amended the year before. The highest court in the state said afterwards that this was the only question in the case worth asking, and then it let the sentence stand. Judd Gray argued the room was unconstitutional after helping to build it, and died in the same chair a few minutes behind her. Lorraine Snyder was 9. She lost her father in March and her mother in January, and then 3 insurance companies argued about whether she was owed the money her father's death had been priced at. What she was eventually paid is not something I can tell you with confidence, and I am not going to guess about a child. Thomas Howard got $100 and a place in every history of photography ever written. And the paper, the actual physical policy, with a forged signature on it and a clause that promised to pay twice for a violent death, did exactly and precisely what it had been drafted to do. Indemnity means to be made whole. Nobody in this house was made whole. The document was.